Ken Good, professional bondsman in Texas.
My name is Ken Good. I'm an attorney specialized in bail law, and I'm also on the board of directors of the Professional Bondsmen of Texas. I want to talk to you about three issues. All of them have been addressed. I want to just say them in a different way. First, warrants. The majority of Texas courts, judges issue warrants, and they don't immediately decide whether to file the case. So the majority of the state, we're issuing a warrant, and then we decide later. That later process is what's causing the issues, because SB6 picks up on arrest, not issuance of the warrant. So we had all that discussion already about is there a bond amount with the warrant? Is it discretionary? Is it mandatory? And I would suggest that the fix for that would be make the PSI reviewed upon issuance of the warrant and require a bail amount issued for every warrant. Because the judge issued the warrant is returned to him. We just had that issue to litigate, or not litigate, but we had the Attorney General just issue an opinion on September the 20th, number 417, about whether the judge, before indictment, before, if they're arrested in another county and they set a bond amount and it comes back to Judge Woodley and Judge Woodley says, that's too low. That's not what I would have in my county. Does he even have the authority to do that? And the Attorney General said he did. He believed he did. We could fix that by saying, when you back it up to the warrant step, not arrest step. I think that would solve that problem. So that's the first issue. The second issue is 17027. That's when you're arrested on a felony and you're on a bond in a criminal case, and then you pick up a new charge in the same county. Mr. Tucker mentioned that we're having issues with that, and I've had calls from judges and courts about it. And what I'm telling them is, if the first case is just the black hole, you're arrested, but no case has been filed, you're waiting indictment, that doesn't count, because the statute says you have a case pending. And so I think the proper interpretation of that is the first case has to be pending, not just on bond. And I think that would fix that. And then I would just point out, in Dallas, we're having a little bit of an issue with 17.027 because everybody goes to the magistrate. And so when you go to the magistrate on one of these charges, they could say, okay, you're not entitled to a bond. What they really mean is, I am not authorized to issue you a bond, so you go back to the jail. And then you're going to come back in a couple of weeks and see the judge. Well, the statute says it's not intended to give you additional time. You're still supposed to do it within 48 hours. So we're having an issue in Dallas and probably some other counties as well about how we implement 17.027. And then I would just highlight what was said by Megan Lavoie. I think we do have some compliance issues. And of course, the one I would highlight is Harris County adopted Rule 9.1 for misdemeanor courts before SB6, and SB6 came into place, and they're still opting to comply with 9.1. And so I think you're missing a lot of cases on your reports. And I think that that's having a devastating effect for the criminal justice system in Harris County. That's all I have. If you have any questions, I'll be happy to answer.
Yes, Representative, and the chair will show Representative Powers. Thank you for being here, Representative Thompson.
Mr. Chair, I don't want to prolong, this meeting because the information is so good. I want to zero in on what you said. A person is charged with an offense, and bail bond amount is set, right? And while they bail out, and pending, while that is pending, but before they are indicted, they may pick up another offense, and it may be in the felony area as well as in the felony area. And before they can get a bail set on the second one, they have to go back to jail.
Well, I think Mr. Tucker was interpreting that to be that you have to go back to the first judge in that situation, but I don't believe that's correct, because there's no case pending on the first charge. So he was arrested on a warrant, he was released on a bond, and then he was arrested on a second warrant for another situation. And so there's no first case pending. So he should not be sent back to the first judge.
So as far as in the ambit of the magistrate, the second offense falls, because there's really no indictment on the first one.
There's no case pending. There's no case pending. Just because when a bond is issued on a warrant, I mean, we haven't assigned a case to a court. It's just, we've assigned it to the JP for governing the bond. But we don't have a case pending. And once an indictment's issued, then a case will be created and assigned to a court. And so think the proper interpretation would be, since there's no case pending, you wouldn't go back to the first judge.
But what are we doing now?
Well, I think he mentioned that their advice was to go back to the first judge. If I get a court or a judge to call me, and I've had several, my advice is that they don't have to go back to the first judge.
Thank you.
Could you explain to us the circumstance in Harris County you alluded to a moment ago?
Yes, so in, Rule 9.1 was part of the settlement in a federal lawsuit where they agreed that they were gonna release, individuals based on what they were charged. They're just gonna release them on a $100 PR bond, and it doesn't cost them anything, it's a $100 free bond. And so no matter how many times they're arrested, they're charged with that same offense, they get the same bond. So, you know, they get released over and over and over. That's what Rule 9.1 is. When, SB 6 was passed, you know, one of the requirements is you can't release somebody without reviewing their criminal history. That's not being done in Harris County for misdemeanor court. And, you know, right when the legislative session ended, you know, one of the commissioners said, well, we're not gonna follow SB 6 because we're under a consent decree. And, you know, it's interesting that that was said because I think, the Fifth Circuit issued an opinion in the Daves case, or the trial court issued an opinion in the Daves case just in the last few months saying that case should be dismissed because it was mooted because of SB 6. And so, but you're seeing severe consequences in Harris County because of Rule 9.1. The last 2 years of data says that 72% of the criminal cases that were disposed for misdemeanors were just dismissed. And then you see that the failure to appear rate is over 80% according to HarrisCountyCourtWatch.com. I reviewed the data for just last month, for the month of August, I'm sorry, and it was over 90% dismissal. So I read that data to say the criminal justice system for the misdemeanors in Harris County is crumbling, collapsing, and the only way they're stopping it is by they're dismissing everything. And people are it's a revolving door. Nobody shows up for court, no penalty. How do we know that's true? There's a billboard at Montgomery County line saying, here we fund the police and we prosecute crimes. And on Facebook in the last week, there was 2 defendants arrested in Montgomery County. The first thing they wanted to know, you're going the wrong way. This isn't the way to the Harris County court, jail. And they're like, you're not in Harris County. And they're like, well, how are we going to get out of jail here? I said, with your criminal histories, you may not. So I think the surrounding counties recognize a problem. We recognize there's a problem, but there seems to be a fight going on between the legislature and the local people in Harris County. And we need to rectify that and resolve it and everybody get on the same page. Until we do, it's going to continue to be a problem.